Welcome to the Case of the Week podcast, where each week we break down a recent decision in electronic discovery case law and talk about the practical impact for you and your clients, and keep you up to date on your obligations with electronically stored information as evidence. If you're a litigator, legal professional, or you love the power of ESI as much as I do, this is the place to be. I'm Kelly Twigger, the CEO and founder of eDiscovery Assistant and the principal at ESI Attorneys, with more than 25 years of experience navigating the evolving landscape of litigation and eDiscovery. I'm a practicing attorney, author, speaker, entrepreneur, and now podcaster who works as a discovery strategist and expert for clients at ESI Attorneys and to provide that knowledge to all legal professionals through our eDiscovery Assistant platform. In each episode, we'll tackle a new decision in eDiscovery case law and how it shapes both your litigation strategy and planning for risk mitigation. If you're ready for blunt, actionable insights that keep you ahead of the curve, and maybe a few laughs along the way, this is your go-to podcast. Subscribe or follow now to start embracing the power of ESI as evidence. Greetings, eDiscovery enthusiasts, and welcome to the Case of the Week. I am Kelly Twigger, the CEO of eDiscovery Assistant and the principal at ESI Attorneys. This week's case is a September decision from 2020 in the matter of Livingston versus City of Chicago. This is a decision from Magistrate Judge Kim out of the Northern District of Illinois. For those of you in the Northern District of Illinois, you'll know that Judge Kim is very active in discovery matters, very well educated, and issues excellent decisions on eDiscovery. He joined the bench in 2010 and has been very prolific and is a great judge. One of the things that I would encourage you to do, and one of the reasons that we pick the cases of the week, is that oftentimes they provide a really great write-up from a judge explaining a decision. You know, a lot of times in case law, we don't get facts or great analysis on particular issues. And so they don't provide a whole lot of fodder for us to grow and develop in eDiscovery. This case does, and make sure you take a look at it. The case before us follows two previous discovery decisions in this case. And in the decision from November of 2019, the plaintiffs were having a difficult time agreeing on a protocol for identifying and collecting information from the City of Chicago's email system. And so in that November decision, the plaintiffs essentially wanted to provide more input on how information was being identified and collected. During that ruling, the city wanted to use its Microsoft tool to search for and export items for review. Ostensibly, I would think that that was probably an Office 365 tool, but it might not have been. There is search functionality available in Office 365 that many parties use to export from. In that decision, the plaintiffs asked that a neutral third-party vendor go in and pull out data from the city's email system and that it be then culled using search terms. So the court agreed to that in November, and where we stand now is that the court had required the city to retain an outside vendor to export emails for a specific date range and then apply initial keyword searches using the plaintiff search term. The court also gave the parties at that time the potential to further refine the results if those search terms were still overbroad. But in the November case, it's important to note that the court rejected the plaintiff's request that those emails that were collected would then be produced without any further review for responsiveness or privilege subject to an FRE 502D order. So that's very important because it's kind of unheard of, I think, for us to have a party ask essentially for a document dump. Document dumps are most of the time what we try to fight against because it's so difficult to manage and it costs so much more money. In this particular instance, we were talking about 9 million documents that were pulled from the search terms. Following the November ruling, documents were pulled and then loaded into relativity. And at that point, we get into the dispute that is the subject of the September 3rd, 2020 ruling from Judge Kim. And so let's talk about this one a little bit. First, what's interesting about this one is that the motion that's filed is a motion for compliance. That's not a motion title that I've ever seen before, but it just tells you if you are a young litigator that you can basically move a court for just about anything and that only certain motions are set out in the rules. In this case, the motion for compliance essentially asked the city to use the search terms and then perform manual review for privilege. And so the fight here is about how the documents that were pulled from the city's email system are going to be reviewed. The plaintiffs want manual review of them to be done, and the city of Chicago wants to be able to use technology assisted review, or TAR, within relativity to be able to cull the 9 million messages down to a reviewable set. So I believe, I might be getting numbers wrong actually, I think the 9 million messages is what was pulled from that 9 million messages. Approximately 15%, or 190,000 documents, were actually identified using the plaintiff's search terms. So it's that pool of 190,000 documents that we're talking about how we're going to review. The question before the court here is a couple of things. One, did the November ruling articulate how the city was required to review the documents? And the court answered that question in the negative. It said, no, we never decided what the review methodology was that was going to be applied here. The plaintiffs also wanted the court to adopt their protocol for TAR, which required the city to use TAR on the entire ESI collection, so the full 9 million documents, instead of using TAR on the 190,000 documents that were subject to the search terms. So really the difference in the parties' position on this case is that the city of Chicago wants to use TAR applied to the 190,000 documents that were responsive to the search terms, and the plaintiffs want to have TAR applied to the full population of 9 million. Plaintiffs' reasoning was essentially that they believe if TAR gets applied to the subset of 190,000, that large swaths of documents could be eliminated based on coding decisions by the team that teaches the TAR. And the court looked at that analysis and said, if we think of it that way, then any coding decision that any reviewer makes is going to be subject to scrutiny, because reviewers make different decisions in manually reviewing documents all the time. And a team that's coding documents for purposes of TAR is not going to be any different. As we get into the court's decision, there's an excellent discussion of the type of TAR that's at issue here, which, as we mentioned, is relativity, and the key features of TAR. And I encourage you to read this. If you haven't used TAR before and you feel like it's something that's too expensive and out of the realm of possibility for you, I can tell you that it's not. And we'll get into some of that and the practical implications later. But you want to really start understanding how TAR is used. And I'm going to read to you a quote from the case because it articulates it really clearly. And I think it'll be really helpful for those of you who aren't as familiar with the TAR process. In AI review, like a manual review, search parameters are used to cull down a collected data set to a review set. That's what we have here. That review set is then put into the AI application, here relativity, where the algorithms use data points collected through attorney review of documents in order to organize the documents in the review queue in a more efficient order. The difference between technologies is going to be the way that algorithm is applied. And you'll want to understand how the algorithm is being applied in your technology versus how it's applied in different technologies. With each coding decision the attorneys make, the technology continues to learn and prioritize which documents contain contextually similar content as documents which are coded as responsive. AI reprioritizes the documents in the review queue every 20 minutes. Now, that is a huge improvement in technology over when we first started talking about TAR way back in 2015. The AI tool does not make any coding decisions about a document's responsiveness, privilege, confidentiality, or issue. Instead, it merely shuffles the order of the documents being reviewed based on coding decisions. All documents marked responsive and ultimately produced are done so by human reviewers. So TAR is taking human review and enhancing it based on technology. It's taking the decisions that your human reviewers are making and enhancing it based on technology. And the cost savings for that kind of technology are astronomical. For example, let's talk about the practical implications of reviewing 190,000 emails. On average, an experienced reviewer who's coding for multiple things, not just responsiveness, but also for privilege and other issue codes, might average between 35 to 40 documents an hour. We'll be generous and say 40 documents an hour. At 40 documents an hour, review of 190,000 emails would take 4,750 hours. Inexperienced coders who aren't reviewing documents all the time will take longer. At 40 hours a week of work, that is 119 weeks of review time. In case you can't do the math, 52 weeks in a year, we're talking about a long time to review. Even with 10 attorneys reviewing, it would take almost 12 weeks just to finish a first pass review. There's usually second pass. That also requires that you have review managers, QC time, constantly tweaking the review based on issues that come up and have to be addressed, coding panel changes. When you think about who the parties are here and you're talking about the city of Chicago, chances are good that the budget for the amount of time and costs associated with reviewing those documents is very limited. In terms of cost for review, we typically say that first pass review is around $1 a document. If they reviewed these documents manually, you're probably looking at in excess cost of about $300,000. That assumes that resources are available or that budget is available to contract that out. Okay, so thinking about this practically, right? Practically, it makes a lot of sense to use any kind of technology that can limit the amount of information that's available. What was a really key fact here for the court, and it noted, is that the parties agreed that generally TAR is a more accurate means of producing responsive ESI than a manual review or keyword searches. So essentially what we're looking at here is the city of Chicago looking to combine keyword searches to find an initial data set and TAR to cull that data set down to responsive documents. The court then looked at the November order and found that no methodology of review had been established, and they specifically rejected that the production would not be made without any further review. This was kind of an interesting quote. While the city may dump 1.3 million pages of documents on plaintiffs with an entry of a 502D order, it also has the right to perform a review to produce only those documents that are responsive and relevant. I found that interesting because if somebody dumped 1.3 million documents on one of my clients, I would take a lot of issue with that. So on the review methodology, what was the court's analysis? This is really important because what the court said is that plaintiffs were not able to provide any binding legal authority to support their request to use keyword searches to provide and review responsive ESI. The plaintiffs argued that because TAR was more effective at identifying responsive documents than traditional manual review, that the pre-TAR culling would eliminate large amounts of ESI. We talked about that earlier and the fact that the court rejected it. And so as we get to essentially what the court held following all of this analysis, they declined to adopt the plaintiff's alternative TAR protocol, which would have required TAR to be applied to the entire 9 million document collection versus the 190,000. They found that the city was best positioned as the responding party to decide on what to search for, review, and produce responsive emails. And as a basis for that, they cited to Sedona Principle 6, which essentially says exactly the same thing. They cited to the fact that the city had disclosed that they were using relativity TAR and the methodology and validation procedure that was to be employed. And what was key to the court's ruling is that the plaintiff's insistence that the city must collaborate with them to establish a review protocol and validation process has no foothold in the federal rules of discovery. And that is a very important takeaway from this case. Also, it's important to understand the context in that here, in this case, as the court lays out, the parties spent more than a year on a protocol and a method for searching and collecting information, which further delayed a 4-year-old case. And we were still looking at weeks to be able to produce information, even using TAR. Remember Rule 1, speed and efficiency in the judicial process. That's always going to be a factor in courts' decisions as to using technology and moving matters forward. So we talked a little bit about some practical implications of this case. Some others that we're starting to see a lot more of these cases where both sides are actively involved in the identification of ESI and the methodology for how ESI is identified. There can be a lot of confusion, misunderstanding, mistrust as to how parties are identifying information, whether they're specifically coding documents in a certain way to exclude them from a TAR protocol. A lot of that requires you to validate when you receive a production. You need to get in there, dig in, look at the data, see what you're seeing, make sure you're getting search results. If you are using search term strings as responsive, a lot of times we'll ask for the search term strings as a metadata field so that we can see how many results we get on a search term string. If you're applying TAR protocols to that, you can still include that search term string as a metadata field. So that's one way to be able to use this layered production, but also be able to verify on the back end. It's really important, as you see from this court's ruling, on the fact that there is nothing in the federal rules that allows the plaintiffs here to have input on how documents are reviewed. So it's important for you to understand that rule and also what are your obligations with regard to ESI. For me, looking at the decisions in this case, it's a surprising level of involvement for the court, but because the parties couldn't agree, the court just had to get involved. So what's going to be really important for you practically is to understand the level of sophistication on both sides, being able to discuss things in a cooperative manner. Sometimes that just doesn't work and you do need to go to the court. Do it earlier than later so you can continue to move the case forward and make sure that you've got facts at hand to be able to demonstrate. And usually those facts include volumes of data. So reducing 9 million documents to 190,000 here is really a big deal. It's always important to note who the parties are. So here we talked about this a little bit, but the city of Chicago, while it's a great big government entity, it is unlikely that it has a staff of attorneys who have weeks upon weeks of time that they can devote to reviewing a document collection. And so you've really got to evaluate all of those things. It doesn't lessen the city's obligations as a party to respond under the federal rules, but it is something that has to be taken into account. And there are proportionality considerations. They didn't come up in this case, but it seemed to me as I was reading the decision that there were proportionality considerations almost in not using TAR. If TAR could reduce the data set of 190,000 by a third or a half or even more, then cost considerations for the value of the information have to be at issue. There's proportionality arguments to be made there. As an overview, the reality is that our judicial system and parties within the system can't continue to support the costs of the volume of ESI and the costs of review. And so we have to continue to develop this technology that allows us to get to these answers faster. Part of what we do for our clients at ESI attorneys and on the eDiscovery assistant side is to constantly evaluate technologies that are out there. And more solution providers are incorporating AI, TAR, call it computer assisted learning, into their platforms. And so the one lump sum cost that you're paying for that platform includes that technology. You should be using it. Use it if only to validate your results on the review side. But the reality is that we can't continue to pay as much money as we're paying in discovery. The solution providers are bringing the technology to the table, and now it's up to the lawyers to use it effectively and to make arguments about it. Costs have gone down a lot. You need to be looking into what solutions are available. Do that before you have a case that needs TAR, or have your lit support folks look into that for you so that you can discuss and review alternatives. So when you have a case, you have 3 different softwares that you can go to and determine what's going to be the best value for that case. That does it for our case of the week. Thank you very much for joining me, and keep doing better discovery.
Thanks for joining me on the Case of the Week podcast. Tune in next episode as I discuss a new decision in eDiscovery case law and identify the issues you need to be paying attention to and how they can help you do better discovery for your clients and leverage the power of ESI. Be sure to subscribe and leave a review to help others discover the show and be kept in the know on all things electronic discovery. I'm Kelly Twigger. See you next time.